how is the division of marital property handled in Colorado in a divorce? It is the bedrock principle that assets and debts, which are really just negative assets, should be divided equitably between the parties. A lot of people hear that and hear equally that it's got to be 50-50, and there's no such law. Equitably means fairly. Now, you can imagine that in many circumstances, fairly and 50-50 are pretty close to one another. But in a lot of circumstances, they're not, because there are differences in how the assets were acquired. There are differences in how the assets were spent or wasted during the marriage. There are also notions of separate property. So in Colorado, what you came into the marriage with, if you don't commingle it with other things, is often considered your separate property, and you leave the marriage with it. And it is not divided equitably between the parties. And then, of course, this is where everything gets interesting. Because if those separate assets are substantial, they can have some effect on what would be fair, what would be equitable in the division of the other assets and debts. So the division of assets and debts in Colorado is handled equitably with a knowledge of the totality of the circumstances, everything that's gone on with those assets and debts, and what the rest of the estate of each party looks like, so that the court can make a determination of what is fair. Truth is that in most divorces, the parties make agreements as to the division of assets and the division of debts, and a lawyer on each side can really help to facilitate that process. In Colorado, assets and debts in a divorce are divided equitably, which is a synonym for fairly. And this is different than community property because in Colorado, it is the assets that were acquired or developed during the marriage that are divided equitably or fairly. What you come into a marriage with is very frequently considered separate property unless it's been commingled to such an extent that we can't see it anymore, right? It's gotten mixed up with everything else, and so it's become part of the marital estate, which is all the assets and debts that were created during the marriage. In a community property state, which Colorado is not, this principle does not exist. In a community property state, everything that comes into the marriage becomes marital property, becomes community property, and is then divided in its totality unless there's an agreement to do otherwise. So Colorado is very different than a community property state in that regard. There are already principles to protect the assets that you came into the marriage with. By the way, they also keep the debts you came into the marriage with as separate property as well. So the differences between Colorado and other states are really important. And if you want a different result, if you don't want to have the notion of uncertainty hanging over your head, an important thing that you can do is to make an agreement ahead of time as to how property will be divided should you ever end the divorce. In Colorado, assets and debts in a marital dissolution or a divorce are divided equitably or fairly. And once people kind of understand that, they kind of start to get the notion that we're going to start splitting things up. And then very quickly, they ask how, right? Because not everything is in neat little columns and rows. We don't have 8 plates. We don't do 4 plates to one side, 4 plates to the other, 4 sets of silver this way, 4 sets of silver that way. Like, how do you actually equitably divide a marital estate, the assets and debts of a marriage? Fortunately, in today's world, we have spreadsheets, either Microsoft Excel or Apple Numbers or Google Sheets. But we develop what's called an asset debt spreadsheet. And Newly Family has developed a proprietary one that we use that makes it very easy to understand. But basically, all the assets and the debts that were acquired during the marriage are put on this spreadsheet. And then you start just putting them in one party's column or the other. Some can be divided, right? If it's a bank account with money, it's pretty easy to split that You can split it 50-50, you can split it 60-40, you can split it 90-10. You can split it 100-0. And then there's the things that are more difficult to divide, collections of things like we were just talking about, silverware, plates, clothes, photos. And then, of course, there's intangibles, right? What are photos worth? And how do you divide them equitably? The answer is you got to work on it, all right? It's difficult because they don't come with values and numbers. But almost everything else does. And the easiest way to do it is to start just trying to allocate things the way that each party thinks is fair. Each party can even submit their own to each other, and we start there, and then we find ways to make it more equitable between them by moving numbers from one column to the other. But logistically, it really is just a matter of counting the things that can be counted and trying to keep it fair between the parties. In Colorado, property that is acquired during the marriage is considered marital property. That includes debts. So things that you acquired or developed during the course of the marriage, including debts, are usually considered marital property as opposed to things you came into the marriage with. You come into the marriage with student loans, they're probably separate property, not marital property. You go to school during the marriage, your student loans are probably marital property. You paint a beautiful, super valuable picture while you're married. That is probably marital property. You buy a beautiful picture while you're married. Also probably marital property. So that's the difference between developed, right, and acquired. And it's the same thing with debts. If you borrowed money during the marriage, that is probably a marital debt. Or if you incurred a liability, you accidentally ran over somebody's prized petunias, and they sued you, that's a debt that was probably acquired during the marriage. The fault of, or the person who did the creation is not really relevant. While you're married, it's considered a partnership, and anything that either of you creates or that you create together is considered marital property. In Colorado, one of the challenges in dividing the assets and debts of divorce equitably comes in the question of retirement accounts, 401ks, IRAs, para, railroad retirements, military retirements. These can be very challenging, especially when part of that retirement was earned prior to the marriage and part of that retirement was earned during the marriage, and the parties aren't even retired yet. If it's something like a 401k, which is a defined contribution plan, it's a little bit easier because we can just add up what was added during the marriage, what was added before the marriage, what was it worth the day you got married. These are numbers we can arrive at. It becomes more difficult with what are called defined benefit programs, like railroad retirement, actually, which is a little bit of both, and para and some others, military retirement, where valuing that benefit at the time of marriage is much more difficult. Valuing how it's grown during the course of the marriage, also very difficult. And so it's much more difficult to determine what happens upon divorce. Fortunately, these are not isolated circumstances, and they happen to lots of people all the time. And there are methodologies that good lawyers will be able to help you with in determining how to divide these marital assets or combined marital and separate assets so that each party can be dealt with and can achieve an equitable share of those assets during the marital dissolution. In a marital dissolution or a divorce in Colorado, one of the largest assets that most families have is their home. And having to deal with how to divide a thing that is very difficult to divide is one of the greater difficulties in achieving a fair and equitable result in a marital dissolution. Very often, it's simply handled by liquidating the asset, selling the house, dividing the proceeds between the parties. But that's not always the case. And at New Leaf Family, we try to work very creatively with parties. Sometimes one party wants to buy the other out. Sometimes the parties figure out a sharing mechanism to preserve the asset for the family, for the children, at least during the course of the children's lives. We are very open to creative ways to divide a marital residence, but this is one of those circumstances where it really takes two to tango. If neither party has the means to buy the other one out, and the parties cannot agree on the creative ways to divide the marital house, then the house will usually be sold. But with some cooperation in a marital dissolution process that is focused on outcomes and focused on solutions rather than conflict, there are sometimes creative ways where the parties can preserve the benefit of this most major asset that they've developed together. In a Colorado divorce, one of the most difficult things to divide is a business. And particularly, of course, now, as you can imagine, there are businesses that existed before the marriage, were brought into the marriage, but then continued to develop and grow during the marriage. There are all kinds of businesses, right? There are businesses that are truly businesses that can operate without either party, and it can be sold like a house and liquidated. There are businesses that rely almost completely on one party or the other or both, and cannot easily be sold. Comes to mind like an artist has an art workshop or a studio, and where they're creating art. That business is very difficult to sell because if the artist is removed from it, it's not really worth anything. In determining how to divide a business in a marriage, in a divorce in Colorado, there are a number of ways. And very often what we'll do is engage the services of a business valuation expert to help determine the value of the business. The easiest way, and what can make a divorce go much quicker and easier, is for the parties to agree on what the business is worth and how to divide it. Very often, one of the things we have to counsel people on is the cost of valuing a business versus the value of the business itself. And very often, in terms of the length of time it'll take and the experts that are needed and the testimony that'll be delivered to a court, sometimes it's just not worth the evaluation to determine the value of the business. And sometimes it is. And if the business has been successful, if the business is worth quite a bit of money, it is good to have lawyers that understand business valuation, that can work with the experts and present a competent, complete case of the value of the business for the purposes of determining how it can be equitably shared.